On November 15, 2018, the parliamentary opposition filed a no-confidence motion in the National Assembly against the coalition government. Today, Chief Justice Roxanne George handed down her ruling on the December 21 vote. In this InfoHub Extended, we take a look at how we arrived at this point.
The administration might have been taken aback when its backbencher Charandas Prasad crossed the floor and supported the opposition in the no-confidence vote. However, the government quickly began charting the way forward. While the opposition called on the government to resign immediately and set a date for national and regional elections, the administration firmly stated that it was standing by the constitution.
But the government remains in office until such times as elections are called. And this is a matter that will engage the attention of the government and our legal advisors as to what are the options available and what is the timeline for those options. But as it is, as I said, the Constitution says elections within 90 days.
Following the passage of the motion, Speaker of the National Assembly, Dr. Barton Scotland, told the House that they would return on January 3, when he would address the consequences of the vote. During the waiting period, the Speaker was presented with a large body of information regarding the validity of the vote on December 21. One such source was the Attorney General's chamber through Attorney General and Minister of Legal Affairs Basil Williams. The AG's contention was that the vote could not have been valid because, among other things, 34 instead of 33 votes were needed for an absolute majority. He had argued, too, that because Charandas Prasad had been holding dual citizenship, his support to the opposition could not have defeated the government. The AG had explained that the constitutional requirement for voting on a motion of no confidence was distinct from voting on the passage of legislation and ordinary motions in Parliament.
The framers of the Constitution, by requiring the vote of a majority of all the elected members of the National Assembly, have set the requirements as an absolute majority. The passage of legislation and motions outside of Article 1066 procedurally only requires a vote of those members present and voting. See Article 168, that is a simple majority. Therefore, Resolution 101 was not passed by the required majority of elected members of the National Assembly.
Upon the resumption of the National Assembly on January 3, Dr. Scotland told the House that while the Constitution allows him the authority to overturn the vote, it would be prudent to seek an interpretation from the court.
The issues over which many have expressed concern require final determination, which will place the interpretation and import of the particular provisions of the Constitution beyond doubt. I find it instructive that much of the information provided relate to cases which saw the courts of other jurisdictions giving guidance to both the Speaker and those national assemblies concerning the constitutionality of conduct on particular issues. Where, as in these instances before us, there are different, even competing views of certain provisions of the Constitution, as well as certain interrelated provisions of the Constitution, all of which fall to be examined, the Speaker on this occasion, and without more, declines the invitation to act in reversal.
That ruling saw the Attorney General moving to the High Court to have the matter resolved by Acting Chief Justice Roxanne George. But that was not before an explanation was given by Prime Minister Moses Nagamutu about the Speaker's ruling that evening, as well as confirming government's intention to go to the court for its interpretation.
The Speaker has clearly stated that there are some very strong and compelling arguments based on legal practices and precedent and other jurisdictions, other countries, that would require that this matter of the vote be examined by what he described as a court of competent jurisdiction. In other words, one of our courts must decide whether the number of votes cast for the respective side in that episode meets the requirement of the Constitution. And he said that while he has the power to revisit and even to reverse a ruling, he would do so only if there are compelling reasons. And if a court adjudicates that the majority, as we had seen on that occasion, did not meet the requirement or the threshold of the Constitution. So in the view of the government, this is a significant development because it means that we continue as a government.
During this time, and this is my very important point to you, the government remains in office. It is entitled to exercise its functions. The country cannot be left without any government at all. A governance vacuum is never permitted. The government retains its full panoply of legal powers, whether that be statutory, prerogative, or common law, and is with jurisdiction to exercise its legal authority.
The government's move to the court was first by Compton Herbert Reed, who through the chamber of Senior Counsel Rex McKay challenged the legality of Charandas Prasad's vote. The respondents in the case were the Attorney General, Speaker of the National Assembly, Dr. Barton Scotland, and the former Member of Parliament, Prasad.
The claim here is restricted to the disqualification of Charandas C. Prasad. At the time that he voted, that he was not qualified to vote as a member of the National Assembly because of his dual citizenship, which affected him at the time of nomination for the 2015 elections, which would have been around April the 7th, 2015. So on that date, nomination day, for the 2015 general and regional elections, he was not qualified to be elected as a member of the National Assembly of Guyana because he had Canadian citizenship. He was under an acknowledgement and obedience as a citizen of Canada.
While the government made its way to the courts to challenge Prasad's vote, the Guyana Police Force had announced that it was investigating an allegation brought against the former Member of Parliament. Police Commissioner Leslie James.
Well, you look at the matter where a Member of Parliament, a former Member of Parliament that is reported to have been involved, allegedly, in some matter, and that's what we're dealing with.
The allegations levelled against Charandas surrounded bribery and the possible movement of gold from the state of Guyana. 3 days after the Compton Reed application to the High Court, Attorney General Basil Williams also moved to the court challenging the December 21 vote to determine whether there was an absolute majority on the night of December 21. The following day, the opposition asked the court to become a party to the proceedings. Then, on January 8, Chartered Accountant and Attorney Christopher Ram made an application to the court asking that it uphold Resolution 101, which states that the no-confidence motion was indeed passed.
In the meantime, President David Granger on January 9 met with opposition leader Barra Jagdeo at the Ministry of the Presidency, where they discussed the way forward following the December 21 vote. The head of state gave an update of the meeting.
The government of Guyana and the opposition in the National Assembly met today, Wednesday the 9th of January, to examine two main issues. The first is, of course, the functioning of the National Assembly, and the second is the functioning of the government. Neither of these two important institutions, the legislative branch and the executive branch, could be allowed to fail. Public services have to be delivered, public order has to be maintained, and therefore the two sides reached broad agreement on how these two institutions, the legislative branch and the executive branch, would continue to function. The second important issue which was discussed was general and regional elections. As you know, the government has had legal recourse to the courts in order to determine the validity of the vote in the National Assembly on the 21st of December. This is quite legitimate, and there's no intention on the part of the government to derail the constitutional or legislative process. We have agreed that the two sides will continue to work together to engage GCOM to ensure that elections are held within the administrative capabilities of the Guyana Elections Commission. I would say in conclusion that we've had a successful engagement. Both the leader of the opposition and the president are concerned about the situation. We would like to assure the public in Guyana that we are working to a solution which they will be satisfied with.
Following that statement from the head of state was a joint declaration from the government and the opposition detailing the agreements met.
On January 30, during his weekly Facebook Live, Prime Minister Moses Nagamutu said regardless of how the Chief Justice rules, there is likely to be several appeals to the Supreme Court and ultimately the Caribbean Court of Justice, Guyana's court of final jurisdiction. He said the outcome of the ruling would be just another step of what is likely to be a long, lengthy process.
I would develop my application in relation to the requisite majority which we contend was not obtained in breach of Article 1066.
On January 23, 2019, the Chief Justice heard arguments by attorney Kamal Ramkaran, who was representing Christopher Ram. He contended that the December 21 vote was valid and should be upheld. However, Attorney General Basil Williams said Ram, in his application to the High Court, committed an error using the statutory interpretation of the Constitution.
It's a simple thing. No less a person than the former president of the CCJ, in looking at our Constitution, there's two categories because of the words all elected members. And the other categories that were, the other articles that were mentioned, if you check them, you'll see it's 2/3 of all elected members. Not that simple or absolute.
The following day, senior counsel Neil Boston, representing Compton Reed, argued that Persaud's vote was invalid because of his allegiance to a foreign country and that he voted against the list from which his name was extracted during the electoral process in 2015.
We feel under 153, since our electoral system is proportional representation and your name is extracted from the list of a candidate, Charandas' name was extracted from the APNU AFC list. So he cannot vote against the list from which his name was extracted. There was no such thing as conscience vote. You got to vote for the list from which your name was extracted.
On Friday, January 25, the Attorney General closed off the third of the December 21 High Court hearings by advancing arguments on the validity of Resolution 101 as subsidiary legislation, which he said is inconsistent with Article 73 of the Constitution, an entrenched provision guaranteeing any one government a 5-year term.
The resolution is a certificate of the Speaker that purports to say whatever is contained in it is conclusive of what transpired in Parliament. It is subsidiary legislation, and as the Constitution is part of an act, the Constitution of the Cooperative Republic of Guyana Act, it is what we call attached to the act and becomes part of the act. So that if any subsidiary legislation is inconsistent with the provisions of an act, then it is void to the extent of that inconsistency.
Meanwhile, as part of the government's response to the Chief Justice's question as to whether the resignation of cabinet will take immediate effect if the government is defeated on a no-confidence motion, Attorney General and Minister of Legal Affairs Basil Williams said, quote, "Cabinet and the President shall resign at the same time the government does. And that time is when elections are held and the President takes the oath of office following the elections as set out in Article 106(7) of the Constitution," end quote. According to the Attorney General, under the Westminster constitutional model, an executive government continues in office with unaltered powers until a new executive government assumes office. He further explained that this principle of continuity of the executive remains unaffected by the dissolution of Parliament. Therefore, dissolution of Parliament does not affect the authority of the government unless the agreement expressly requires the input of the Parliament.
This is an unprecedented development for Guyana, to have a vote of no confidence filed in the National Assembly, and on a slender one-seat majority, the Parliament had deemed that the motion was carried, and the Speaker had said that he had doubts whether that was the requirement under the Constitution, what is called the need for an absolute majority. And therefore, we expect to see that the government will continue in office, will continue to discharge its functions. The leader of the opposition agreed with the president that the government remains in place, and that 100%, he said, and Parliament is open, and the work of the state continues.
The acting Chief Justice on January 31 ruled that constitutionally, dual citizens cannot serve as members of Parliament.
Conclusion. Thus, I hold that the declarations sought in paragraphs 1 and 2 are granted. The effect of these declarations is that anyone who holds dual citizenship as defined within the parameters of Article 155(1)(a), as discussed above, cannot lawfully be nominated or elected as an MP.
The acting Chief Justice explains what Guyana's constitution says with regards to this matter.
Article 156, subarticle 1, subarticle D of our Constitution provides as follows. A member of the National Assembly shall vacate his seat therein, subject to the next following paragraph. If any circumstances arise that if he were not a member of the Assembly, would cause him to be disqualified for election as a member thereof by virtue of the preceding article of any law enacted in pursuance thereof. This is to say, if, as in this case, a member is found to be disqualified due to dual citizenship, he would be required to vacate his or her seat, or rather he or she would be required to vacate his or her seat, though any challenge regarding such would have to be commenced by way of petition.
In her ruling, the acting Chief Justice noted that this will have implication for all dual citizen members of Parliament who now have to resign or renounce their citizenship.
Following the January 31 ruling by Acting Chief Justice Roxanne George, Attorney General and Minister of Legal Affairs Basil Williams announced that government will be filing its case at the appeal court.
It's just another day in the life of the courts, and the ruling of the Chief Justice is stage one. We had said that they needed to have 34 votes and not 33. And why is that? It's because you require an absolute majority, what we call an absolute majority, as against a simple majority. The simple majority is 33.
Following the Chief Justice's ruling today, the Attorney General explained that absolute majority is stronger than the simple majority in the 65-member Parliament, and therefore
33 cannot be the same vote for the absolute majority. And in any event, we are talking about a Parliament at 65. It's an odd number Parliament, and the cases show when you have an odd number Parliament, to get the majority, you divide it by half plus 1. And when you divide 65 by half, you get a fraction. And since there are no half human beings, you have to round up the fraction to the next whole number.
The Attorney General said that the government is confident that they have a strong case to move forward.
And just as happened in Cedric Richardson, where we went on appeal to the Court of Appeal, and then from the Court of Appeal to the CCJ where we won it, and stopped Jacques Diop from saying that he could have a third term, we're going all the way again. All right? So that's what I want to say, and there's no need to weep and gnash teeth. Our courts are a hierarchical system. Our final court is the CCJ. So, like in the GCOM chair, when Nandala them lost, that they appealed to the Court of Appeal. So it's all part of the process. So Nothing is over until the CCJ makes the final determination.
The acting Chief Justice will give the judgment on Wednesday, February 6, 2019, so that the government can prepare its appeal.
You have been watching InfoHub Extended, where we took a look at the events leading up to the High Court ruling on the December 21 vote. Goodbye now.